All right. Thank you all for joining us today. Uh, Before we begin, just one quick housekeeping item. Today's webinar is being recorded, and you'll receive an email in the next week when the replay is available. To start, I just want to take a quick step back and think about what it really means to plan your estate. Estate planning is one of those things that most people know it's important, but it's something that's really easy to put off. Some people hear estate planning and assume it's only for the wealthy. Others may feel it doesn't apply to them quite yet, and some may already have a will and feel like they're covered. But the reality is, estate planning is relevant for almost everybody, and having a plan in place is one of the best ways to protect the people and the priorities that matter most to you. So, wherever you are today, the conversation is designed to meet you there. And our goal is to help you think differently about what estate planning means to you and your family, but more importantly, to help you walk away with better questions to ask. So today you'll see that you'll be hearing from myself and two other Appella professionals who bring a different perspective to this topic. My name is Sam Morella Jr. I'm a senior financial advisor at Appella Wealth. We provide comprehensive wealth management to successful families and business owners, and with the goal of helping them make smart and coordinated decisions that go far beyond just investments. You'll also hear from Paul Morella. He began his career as an estate planning attorney before working on Wall Street as an equity trader. And then in 2001, co-founded Morella Financial Group, and today continues his work with clients here at Appella. And last but not least, Sean Steele, former attorney with over a decade of experience as a certified financial planner in the Washington, D.C. area. And Sean serves as a subject matter expert for the CFP Board of Standards and counsels clients in all areas of financial planning, including retirement and estate planning. So together, what we're going to do is we're going to look at estate planning not only from a legal standpoint, but from a practical real world perspective as well. So the goal is simple. It's to simplify estate planning and focus on the decisions you're going to need to make, the questions you should be asking, and the importance of having the right people in place to tie it all together.
So our goal today is really to make this interactive. There's a Q&A box. You can please feel free to put your questions on there. We want this talk to be more than just two lawyers talking in big legal words, legalese. And instead, I think we want to pass some of our experiences on. We want you to think about keeping it simple, and we want you to have better questions to ask. We're going to give you a perspective both from the attorney side, but also the advocate side. And when I say advocate side, your Appella advisor has a lot of knowledge in a lot of areas of managing wealth, one of which is estate planning. So if we can have you work with that person, have better questions to ask, it's going to make your experience with the lawyers and all of your professional advisors a little bit easier. And it's all about easy because it's hard enough, as Sam said, to put it off. We're going to have you have better questions to ask yourselves, most importantly, and also your professional advisors. And the hope is to have you avoid the emotional and what we call procedural pitfalls of doing this. Because when you have emotional pitfalls or procedural pitfalls, all that does is it leads to paralysis and, basically nothing gets done. It's really easy for people to put off. So the reality of estate planning is this: 6 out of 10 people do not have any estate plan at all. 3 out of 10 people only have a basic will. 1 out of 5 people have reviewed it in the last 5 years. And if we see this problem, I say, my gosh, that seems like not that many people have that. Well, you know what? It's okay. Don't worry about it. You're probably asking why. Well, it doesn't matter because each and every person on this call, you know what? We have something in common. We already have a plan. And the plan, I guess the good news, bad news, the good news is you have your plan. The bad news is it's your state that wrote it for you. So we would rather have you write your own. And I think that's a good question to ask yourself. Would I rather have my plan or the government's plan, the state's plan? So how do we do it? I think the best thing, when I was a lawyer starting out, I called him an old salt since passed, he said, son, you will never be a great attorney when you have all the answers. You'll be a great attorney when you know the right questions to ask. So we want to move this in the direction that you want it to be. So send any questions to the Q&A box. And so having said that, our little introduction, Let's get started.
Great. Thanks, Paul. So, any educational discussion, in my opinion, I think should start out by giving a definition of the topic at hand. So I'm going to start with you, Paul. Why don't you give us a definition of estate planning?
I think to have a definition of estate planning, I think you need to start with what an estate planning is not. An estate plan is not a will, a trust, powers of attorney, or set of documents. Instead, estate planning is about the people, not the paperwork. It's a game plan. It's a set of instructions. It's a roadmap. It's a plan to manage your affairs when you're gone. Now, we have to define the term gone, because most people think I'm gone when I die. And that's right. That's the easy way. It's easy and it's final. It's black and white. You're either alive or not. Where it gets even more difficult, and what people fail to recognize, is that estate planning is also when you're in a condition where you're incapacitated, you can't speak for yourself, you can't act on your own behalf. And we'll make very few promises, but everybody on this call and everybody you know is going to need an estate plan at some point. And I think to make it simple, right, think about the facets of estate planning. There are two. We have to be concerned for the person, the human being, Paul Morella. What if he gets sick? Somebody will take care of me, hopefully in a way that I like. But we also have to take care of the money. And in today's both litigious and fraudulent environment, we've got to worry about protecting people's money. So the plan, the people around you are a couple. We're going to start with fiduciaries. Well, what the heck's a fiduciary? We, all of your appellate advisors, are fiduciaries for you. They are there to act on your own behalf. And we need fiduciaries in our living will, our healthcare directives, and our power of attorney. We need people to act on our behalf. And when we get these people right, and Sean's going to touch on this in a few minutes, the plan gets right. So estate planning is comprised of powers of attorney and wills and trusts and beneficiary designations. We don't have to worry about the definitions now, but it's the people that are there to act on that. That's what the estate planning really is. So hopefully we keep it simple, keep the questions coming. Thank you for coming.
Yeah, so Paul mentioned a couple of the documents. We're going to touch on those in a bit. I'm going to bounce over to Sean here. Now that Paul gave us a definition, why does estate planning matter? Why is estate planning so important?
That's a great question, Sam. And I love how Paul kind of framed it. At the heart of estate planning, it's really about people. Now, Paul kind of led with, estate planning is about people. It's not the paperwork. It really is about the people. And planning helps protect your family from friction and conflict. And friction and conflict can come from a wide variety of sources. It can come from having no plan at all. It can come from putting the wrong person in the wrong role. And most families are going to experience friction and conflict at some point. But when it comes to estate planning, friction and conflict can permanently damage relationships and lead to costly legal battles. And you do not have to be in the top 1% for this to happen. And to make a point, I want to begin with a question that I want everybody to think about. And my question is this: what do Jimi Hendrix, Howard Hughes, and Abraham Lincoln have in common? Now, on the surface, it would seem that they have nothing in common at all. Jimi Hendrix was best known for his skill as a musician and a guitar player. Howard Hughes was an eccentric billionaire. He was best known for acquiring Trans World Airlines, TWA. He had a very strong passion for aviation. The picture here looks to me like it was taken on board the famous Spruce Goose. And Abraham Lincoln, of course, was the 16th president of the United States. And before that, he was an attorney. So what do all of these people have in common? The answer is they all died without a will. Now, it might be surprising, like we kind of talked about earlier today, that when you die without a will, there is a plan in place for you. And what happens is the laws of your state are going to determine who gets what. And if you don't have any heirs within the meaning of state law, it could be the state that becomes the owner of your assets. Now, most of us would probably prefer to leave our assets to a family member or a friend or perhaps even a charity. But when we die without a plan, we give up the right to direct where our assets are going to go. And our heirs are going to have to go to court, and this could take years and create lots of conflict. And the final result may have nothing at all to do with what you would have wanted. When Jimi Hendrix died, the litigation over who is entitled to what lasted 50 years. So when Jimmy passed, Jimmy's father inherited everything. Jimmy's father ultimately left everything to his adopted stepdaughter, and Jimi Hendrix's brother was cut out. Now, as you can imagine, that resulted in more litigation, not to mention what impact this had on the family relationships. When Howard Hughes died, 600 people tried to claim part of the estate, and the estate had to deal with 40 fake wills. Now, in this day and age, you do not have to be a billionaire to have to fend off fraudsters and, identity theft and all that kind of thing. But the point here is, by not planning, it's creating scenarios where there's a potential for conflict that can lead to damaged relationships, costly legal battles, and you may have to fend off, unintended heirs and fraudsters. And so the question becomes, well, how do we prevent this? And the good news is the question is really simple. We just need a well thought out estate plan. And so that's why it's really, really important that we get an estate plan that reflects our values and our wishes in place.
Great. So I'm going to stick with you here, Sean. So, in the financial world, we have no shortage of complicated terms and acronyms and phrases. Probate is one of those words. Most people have heard of probate. They know they should avoid it, but not everybody knows exactly what probate means. So Sean, can you explain probate and, tell us why we should avoid it?
Yeah, it's a good question. So when someone dies, the assets have to be retitled from the person who died to someone who's living. And there's several ways we can do this. If an account has a beneficiary on it, the account is going to go to the person who's listed as the beneficiary. We're going to talk about trust in a little bit in today's session, but if an asset is held in a trust, it's going to pass according to the terms of the trust. Now, if we can't pass an asset either by a beneficiary or by a trust, then we're going to have to go to state court. And the state court is going to retitle those assets either according to the will or according to state law. And that process of going to court is called probate. Now, we have 2 states represented on today's panel. And how much work that process of going to probate, going to court to have the assets retitled, how much work that is, very much depends on what state you're in. So here in the Washington, D.C. area, probate is an enormous pain in the neck. It requires a lot of time, a lot of effort, and it's generally something to be avoided. In Pennsylvania, where Paul and Sam are, the attorneys would tell you probate's not so bad, and they're not generally concerned about avoiding it. But bottom line is probate is just the process of having to go to court to retitle assets from someone who died to someone who's living.
Great. Thanks. So now the fun part, that gives us some foundation. Let's talk about the documents. So I'm going to bounce back between you two on the different estate planning documents, what each is designed to do. I'm going to start and kick this off to Paul and give him the powers of attorney. And there's a couple of them. So I'll let you start here. Oh,
These are, by the way, a quick update. We have a big storm coming through right now. So if for some reason we get kicked off, I've got a plan B, but I just wanted everybody to know that that's a possibility. So the first set of documents we're going to call the what if you live documents. Remember, you're gone, but you can't act on your own behalf. So you're still living, not gone to the funeral. And the first one is we're going to talk about powers of attorney, living wills, healthcare powers of attorney. They're sort of similar. And when you think about it, they are tools that allow someone to act on your behalf. It might be medical, it might be financial. And if you think about things like HIPAA, anybody that's been to the doctor in the last 10 years, it's just an awful process. And this is your document to have somebody help you make medical decisions for you, admit you if you have to go to a nursing home, allow surgeries, whatever it may be. It's also things financial. And in our litigious world, in our fraudulent world, financial institutions hate financial powers of attorney because financial powers of attorney steal from people. So they're very powerful documents, which then leads us to the fiduciary, which is called an agent under a power of attorney. So the question you have to ask yourself is, who would I ever trust enough to be able to manage any financial or medical affair that I want? Sometimes you have kids and it's easy, and one of the kids might be more apt to do it. I think you have to ask yourself, what do I want them to do for me? Our recommendation, Sean will probably touch on this in a couple of minutes, is have them written more broadly. Because if you don't have somebody that you trust to do everything broadly, you probably have the wrong person. So that's the kind of the power of attorney, healthcare power of attorney, someone to act on your behalf. You need fiduciaries, multiple levels. So if you name child A, you may want to name child B or C as a successor. Then there's something called a living will. And a living will is something when you're in a terminal condition. It's a don't put the plug in document. And it's telling your medical professionals, if I'm really, really bad and I'm going to go soon, just let me go now. Don't keep me alive. The question you have to ask yourself is, do you want one? Are you willing to make that decision and put it down on paper right now? So there's a lot to this. We believe in keeping things simple. We like durable general powers of attorney, which are written very broadly so somebody can act on your behalf. And then you name a fiduciary, you name an agent, and then you have successor agents in case that person isn't with us anymore or can't act on your own behalf.
You know, Paul, one of the things that I think is interesting about, we were talking about how you need to trust the person who's your agent, especially for power of attorney. And sometimes when clients meet with the attorney, the powers of attorney can be drafted two ways. They can take effect right when the person signs the power of attorney document, or they can require an event to occur. It's called a springing power. And sometimes people will kind of like that springing power because that means the person can't act right away. The problem that we've seen with the springing power is if that event never occurs, then your agent can't act. And, to Paul's point, maybe if you don't trust the person to act, maybe that's the wrong person, wrong role. Maybe that's not the right agent for you. Because if you put a condition on there, it may prevent the person from acting when you need them to act the most.
Great. Before we get to the next one, there have been some questions coming in. We're going to save these till the end. Some of these may get answered. So keep the questions coming in and we'll make sure we get through all of them at the very end. I'm going to switch over to Sean here. And I'm going to give him another fancy acronym. This one probably most people probably haven't heard of, and but it's critical and it does come up. This is a POLST. So Sean, talk to us about POLST.
Yeah, so being in finance, we love our acronyms, right? So this one stands for Physician's Order for Life-Sustaining Treatment. Okay, that is a mouthful. It sounds like a bunch of legalese, and I get it. The good news here is it's not as complicated as it sounds. This is something we would generally think about for somebody who's nearing end of life or is very seriously ill. So it's a medical order. So if you think about when you go to the doctor and the doctor gives you an order for some lab work or a procedure, it's a medical order just like that, except it allows you to specify, what treatments you want and don't want if you're not able to communicate. So for example, do you want CPR? Do you want to be taken to the hospital or stay at home? Do you want to be given every treatment under the sun that might possibly work, or only give me treatments that are going to keep me comfortable? So on the surface, this sounds a lot like an advanced medical directive. But the difference here is the doctor prepares it. So you would go to the doctor, you would discuss your wishes with the doctor, and then the doctor would give you an order. Now, if you or someone in your family is in this situation, you want to keep a copy of it on you. You want to tell your family members about it, and you want to keep a copy of it at home in a highly visible place. So if the paramedics are called, they can look around and see it and make sure that your wishes are carried out. Be sure to make sure that your advanced medical directive and your physician's order for life-sustaining agreement say the same things. You want to make sure they agree. You don't want to have a conflict between those two documents.
Great. I'm going to stick with you, Sean, just because, as you mentioned, probate is state dependent in a lot of cases, and your area, Washington, D.C., tend to utilize trusts in more cases than in up here in Pennsylvania. So trusts are a generic term. They can feel intimidating. They, expensive, complicated, maybe only for the wealthy. So a lot of misconceptions here. So let's clear that up and kind of give a high level trust overview.
Yeah, so for today's conversation, we're going to talk about two kinds of trust. We'll talk about revocable and irrevocable trust. We'll start with revocable trust first, and this is sometimes referred to as a living trust. But what it allows you to do is transfer assets into a trust and manage and control them during your lifetime. You can amend or revoke the trust at any point in time. And as a practical matter, it's very similar to having assets titled in your individual name. However, there's one key benefit here. Assets titled in a revocable trust do not have to go through probate to pass to your heirs. They're going to pass according to your trust without having to go through probate. So if you live in a state where probate is a big deal, a big pain in the neck, and it's something you want to avoid, a revocable trust can be very helpful. Revocable trusts can also be very helpful if you have some complexity that you need to plan for. They're not very expensive, especially compared to the alternative. The attorneys in our area here like to tell us they make a lot less money on a revocable trust than they do helping administer a probate estate. So you can think of a revocable trust like, I'm paying a little bit more on the front end to save a lot of time and effort on the back end. Now, if you do have a revocable trust, there's one more thing we need to think about, and that is we need to make sure we get assets like your home, your bank account, your brokerage account titled in the revocable trust, because if you don't complete that last step, these assets would pass through probate, and the whole idea of doing all this is to avoid probate. So we need to make sure that last step.
So a question came in: if you forgot a single asset when assigning beneficiaries or when adding to the trust, but you have a pour over will your executor be able to avoid probate? So that's to your point, right?
Yeah.
Answer to that would be no, right? You're going through probate and you are, right back in the pit.
Yeah, that's a good question. So the way a pour over will works is the will says, whatever's not titled in my trust or has a beneficiary on it, I leave to my trust. But the problem is if it's not titled in the trust, then you're going to court to have it retitled in the trust. So that's a great question.
Yeah, the other question that came in, Sean, is would a car be considered an asset, and does that need to be put into a trust?
Yes, depending on states. So some states, depending also the value of the car, some states might have a de minimis estate requirement where you have an abbreviated probate process. Other states here in Virginia will allow you to put a beneficiary, basically a transfer on death on the car deed. So it depends on your state. Talk with your financial advisor and talk with your attorney.
And the second part of one of the earlier questions is, can an executor handle everything without an attorney, assuming no competing interests or fighting between heirs?
Paul, you want to take that one?
Yeah. So I'm an attorney in my state. When my dad passed, my brother and I are executors, and we hired an attorney. Because I didn't want to do anything wrong. There's certain rules, there's certain things that you have to do to protect your interest. I would never, ever, ever recommend it, but people do it. Sean?
Yeah, and to give you some perspective on what you'd be signing up for, like here in Virginia, if you have to go through probate, the court wants to make sure everything's above board, right? And so the court is going to have the executor submit detailed records of the assets, all the money that has been spent. So the court wants to know everything that's going in and out of the estate. So you're signing up for a lot of work to do it yourself. And you run the risk of, something going wrong and heirs getting upset.
Yeah. And just one last question for the audience. Where do you see in your area, what's a common example of where a trust is used?
So on the revocable ones, the primary one is to avoid probate. If you have some complexity, you might also use a revocable trust for that. But this is a perfect segue into kind of talking about irrevocable trust as well. Now, irrevocable trusts are generally, kind of like what they sound. Generally, once you set them up, you can't change or amend them. They're generally used if you want to put limits on how money can be used, or you want to guarantee that assets are passed to certain people. And as Paul likes to say, you think about an irrevocable trust when there's something you want to protect. So some common scenarios where you might consider an irrevocable trust would be like, let's say you want to leave money to a child, but the child's not yet old enough to manage the money. Or you want to leave money to somebody who had a history of gambling or addiction. Or, you would just be super offended if somebody received their inheritance and they went out and bought an Italian sports car with it. those are all scenarios where you consider an irrevocable trust. To give you three more, let's say if you wanted to plan for an unlikely event where something happened to you prematurely, you wanted to make sure your surviving spouse had money available. But if your surviving spouse remarried, you want to make sure that that money then passes down to your children. You might consider an irrevocable trust in that case. Two more would be if you have a child with special needs. There is a specialized type of irrevocable trust called a special needs trust. This is used when preserving public benefit eligibility is very important. So that would be another reason to consider one. And then lastly would be if estate tax is a concern for you, that would be another scenario where you might consider an irrevocable trust. Now, we kind of talked about, at the beginning of this, asking the right questions. If you're going to have a trust, we also need to ask the question, who's going to be trustee? Now, the trustee's job is going to be to manage the money when you're not able to. And that's going to be the person the beneficiary goes to when the beneficiary wants, a distribution from the trust. So we do need to think about what's the relationship between the beneficiary and trustee. If you're going to have a trust for one of your children, but, you're going to have another child serve as trustee, what would happen if the child who's trustee has to say no? Is that going to create friction and conflict between your children? If it might, you might be better off having a professional trustee serve in that role instead of having one of your children do it. So lots of questions to think about, and those are some scenarios where you might consider an irrevocable trust.
Thanks. Paul, I'm going to switch over to you. This is probably the estate planning document that people recognize first, but it's also the one that's probably the most misunderstood. So can you walk us through what a last will and testament actually does and what people are often surprised to learn when they review theirs? And as part of that, let's touch on beneficiary designations as well, just because certain accounts or assets may pass outside of the will entirely.
And I think we'll be able to answer some of the questions that are being asked with this. So I'm going to start with beneficiary designations. I think logically makes a little bit more sense. So what's a beneficiary designation? Typically on things like life insurance, annuities, company retirement plans, that could be 401ks, 403bs, money purchase pension plans, simple IRAs, Roth IRAs, transfer on death accounts. You get to name a beneficiary. And when you name a beneficiary, that money goes directly to the beneficiary. So if I name Sean, the beneficiary of my life insurance policy, and my will says everything goes to my wife, Sean still gets the life insurance policy. So any beneficiary designation would supersede the will. Any beneficiary designation also avoids probate like a trust would. Remember, your probate estate will only give away any asset that you haven't given away otherwise. Probate only handles an asset that wasn't given away otherwise, and that's where you have a will. So the will is to dispose of this thing called the residue, which is everything, legally is whatever wasn't given away. So why is it important? There's a number of reasons it's important. There could be, in our state, there could be inheritance tax reasons. There could be income tax reasons for things like IRAs, Roth IRAs, company retirement plans. And it allows you to direct that money that avoids probate, avoids the delays of probate. Will it save you money on taxes? And I'm talking about proper beneficiary designations. It may. It certainly helps in the world of IRAs and Roth IRAs. A question to ask is, where are they? Where do I keep my beneficiaries? In modern day, you put your beneficiaries on your company website. You put them on your Fidelity or Schwab account. We as Appellate advisors can get those for you, but it's sometimes difficult. I remember the day, I'm old enough to remember, that we used to keep beneficiary designations at the company in like the office, the COO's office desk drawer. I mean, think about that, how much money could have been riding on that. And so it's really, really important that you consider beneficiary designations as part of your estate planning. Now, last will and testament, touched on earlier. This, 500 years ago, the king took everything. You died, the king got the money. Then he said, all right, I'll let you give the money to your kids. So they created this whole process that ensures that money goes from your generation down to either the next generation or whoever you want, making sure that the right people get the money and people aren't stealing it along the way. So you have to ask yourself, do you have one? What does it say? And then who do I want to have my money? And then who's going to act on my behalf? So if one of the questions was, how do you avoid probate in New York? Is it required even if you have a will? Yes. So if you have a will, anything that goes through the will is going to go through that process called probate. There was another one. We've got a bunch more. I apologize. Should a house jointly owned by a husband and wife be in a trust, revocable or irrevocable? So typically, if you're in a trust state in Pennsylvania where we are, you would leave your house registered jointly. But the people that do the trust would typically 99% of the time re-register that home into the name of the trust, and it would pass through a trust, thus avoiding probate or for whatever other reason it may happen. But we don't see too many of those in our state. In Sean's state and most of those other trust states, you would.
Yeah, so in states where revocable trusts are used to avoid probate, oftentimes the attorneys will prepare the deed, you usually have to update the deed of the house, and they will prepare the deed to update the house and retitle it in the trust for you as part of the whole process to make sure it gets done. And they don't charge very much to do that, but it guarantees it gets done.
Yeah. One of the big mistakes we see with trusts is, like Sean said earlier, people they fail to register the assets in the name of the trust. So getting back, go ahead.
I was going to ask one more question that came in to Sean or you, Paul. What if one owns property in 3 states?
Oh, that is a great question. So that's even more reason to have a revocable trust. So anytime you start thinking about state property in different states, then you start thinking about, I'm going to have to open up probate in my home state, but then I'm also potentially opening it up in all of these ancillary states as well. So for us, that would be, another reason to consider a revocable trust.
So fun fact, I called my attorney, who's an attorney I used to work with way back when, and my mother, Sammy's grandmother, has a condominium in Stone Harbor, New Jersey, outside of Pennsylvania. And I said, Heidi, do I want to create a trust so I can avoid this ancillary probate thing? And one of the lawyers in the firm who's licensed in the state of New Jersey said, it's not worth it. Probate isn't that important in the state of New Jersey. It's not that hard, and therefore don't bother doing it. So I guess the answer to the question is, it depends on the states, right? Because in Jersey, maybe it's not a big deal. Apparently it's not a big deal, but I have a client who has a house in California, and that is in trust because that is a giant pain in the neck because that is a trust or difficult probate state.
Yeah.
So getting back to the will, just to clean this up, your will is to give away whatever hasn't been given away elsewhere, and it allows you to pick the people that you want to get your hard-earned life savings. Now, the questions you have to ask is, who gets what? And then who's gonna pick all this stuff? Think about if, God forbid, you got struck by lightning yesterday, somebody's got to come into your house, figure out all this money stuff, and sell the house, sell the car, sell everything to then pass it on to whomever. Let's say you have 3 kids. I mean, it's a yeoman's job. You need somebody with a fair amount of competence, not necessarily legal competence, but the executor is that person, and that's extremely important. Then you have to ask yourself, who do I want to have the money and when? Because if the beneficiaries are, if you're an 18-year-old boy, I was an 18-year-old boy once, so was Sean, so was Sam. I would not have been very good if somebody laid a couple $1 million on me. It would have been better if somebody would have put that money in trust for me so I wasn't buying the Italian sports car. So a lot to it. That was a lot of words, but really, really important that you check all these things and you ask yourself, is this what I want it to be?
No, I think that's great. I think the last part, I'm going to pose this to both of you because this is not a document, and it's probably the most important part of all of this and the entire estate planning process. Think of communication as the glue that holds the plan together. So you can have all the right documents, all the right people, all the right intentions, but if your family's left in the dark, the plan may not work the way you hoped. So let's talk about communication and how important that is in this whole entire process.
I think
Paul, why don't you go first?
I think the 3 most important words in multi-generational wealth planning are communication, communication, and communication. We see it. I saw it in my family. I'll give a really quick story. My dad wasn't well. We didn't know how long he was going to live, but we knew it wasn't going to be many years. And I was over at his house one Saturday morning. He said, "Go grab a pad." I grabbed a pad and he started talking for about a half hour. And I wrote and I wrote and I wrote because he told me what he wanted done. And you know what? We got it done. And I communicated with my siblings, and then ultimately the grandkids. It is so vital for you to be able to pass on this information, especially your values, to whoever it is that is the next generation, whether it's nieces, nephews, kids. Sean, what do you think? What would you add on top of that?
Yeah, so sometimes, the idea of, how do I communicate this with family members becomes a bit of a paralysis by analysis, right? So some people say, I like the idea of communicating with my family, but I'm not ready to show them my balance sheet and let them know how much I got. You don't necessarily have to communicate in terms of dollars. You can communicate in terms of, I've had a estate plan. These are where the documents are located. You can tell, as Paul was mentioning, you can talk about the values. What were the values that went into the decisions you made in your estate plan? And I think that conversation alone, just talking about the values, is hugely helpful. So you don't necessarily have to disclose, here's how much I have, here's how much you're going to receive. That information can be particularly helpful as your next generation is doing their financial plans, but you don't have to disclose that if you don't want to, or you don't feel comfortable, or you don't think it would be appropriate. You can certainly talk about all these other things, like especially the values that went into the decisions that you made.
I think I can't stress Sean's word of values enough. It is so vital. And in full disclosure, I am in favor of more disclosure than less disclosure in the right situation, in the right family. We've seen more disclosure make more sense for our clients.
Yeah. So I'm going to jump over to you, Sean. Just to be honest with the audience here, and because a lot of what we talked about is I guess somewhat straightforward, but real life can make things difficult. So let's talk about where estate planning can get complicated in different family situations and what you've seen in your experience.
Yeah, so that's a great question. So a lot of people tend to think of complicated estate planning means only for the high net worth. And that's really not true. There's a lot of everyday common scenarios that can create some complexity that we need some careful estate planning for. Now, we probably all remember the Brady Bunch. It was a very popular television show. It had a very catchy theme song. Do not worry, I am not going to sing it. But once you hear the song, you remember it forever. But it told the story of Mike and Carol Brady, and they each had 3 children of their own, and then they got remarried, and then they had 6 children. And the point where I'm going with this is second marriages are one of the things that can create some complexity that requires some careful planning. And if you're thinking about a second marriage, or you have a second marriage, you want to think about some questions. And so one of the questions to ask is, how do we want to handle the assets each of us had before our second marriage? How do we want to handle the assets that we accumulate during our second marriage? Sometimes if an estate plan is not properly drawn up, what can happen is the heirs receive different amounts depending on who passes first. Now that's probably an indication that something's wrong in the estate plan, because it really shouldn't matter who passes first. The heirs should get the same amount either way. But that's just, that's an example of one thing that can create some complexity. Personalities in our family can create complexity. So we want to think about, how do the personalities in our family interact with each other? What are their skills? Is there somebody that we know is going to be a problem? Now, we all know somebody in our life who is, likes to tell everybody what they're doing wrong and how things should be done. This is the person who's often wrong, but never in doubt. But this person can create a problem for your executor. And so we want to make sure that, your executor, his job as easy as possible. And so the way that we can do that is by making sure we've got the right person in the right role. We've got your wishes clearly laid out, and we've got your estate plan all buttoned up.
Great. So Sean, I'm going to stick with you again on this one. Your estate plan is only as good as the last time you looked at it. So why do you need to keep your estate plan always evolving, and why is it always ongoing?
Yeah, so estate planning is not something we do once and then never ever look at it again. We need to look at it every few years because circumstances change. We want to make sure it reflects what you want. Major life events are a great time to look at your estate plan and make sure it still reflects what you want. I talked about second marriages ago, but if you happen to be finalizing a divorce, chances are your estate plan is also going to need some updates. If an ex-spouse is still listed as a beneficiary on an account and something happens, that's where it's going to go, and that may not be what you want. So the point is when you have major life events, we need to make sure we're reviewing your estate plan and making sure it reflects what you want. We do need to periodically review them because we want to make sure that your financial accounts and your legal documents are working together properly and producing the outcome that you want. And if we don't do that every few years, it can get out of alignment with what you want.
All right, Paul. So what to do next? The big question. So obviously, Sean touched on this is a living process. It's not a document you file away. Let's close with kind of the most important question that for those who are watching, what to do next.
Let's start with what if I'm gone and I'm not around anymore? Gone. You want to be thinking about who gets what. And I think the easiest way for you to think about it is you get 100 pennies and you can't give away 90 and you can't give away 190. You have to give away just 100. And if you can figure out who gets those pennies, your appellate advisor, your attorney can figure out a way to structure it. Now, if you've got 4 kids and they all get a quarter, it's somewhat easy to do that. It's usually 25, 25, 25, and 25. But you have to figure out who's going to get the pennies. Then you have to ask yourself, am I willing, if I leave this earth today, am I willing to give that money to those people outright? Am I just going to have them have unfettered access to it? Or do I need to keep it in a trust? There's other trusts called testamentary trusts, or you could do it through your living trust. And if you're not of a certain age, that money remains in trust, so your grandchild doesn't buy an Italian sports car. So then you need to say, all right, who's going to help me when I'm gone? If I'm gone, who's going to be my executor? There was a question of what's the difference between an executor and a trustee. The executor is the president of your estate. They make the decisions, they marshal the assets, they sell your house, they sell your stuff, they put it all in an account, and they slice it up based on the percentages you put in your will. A trustee manages your affairs during the life of the trust. The trust might end when you die. The trust might live long after you die. But the trustee is the president of the trust, and they make the decisions, invest the money, file the tax returns, and manage all that. So that's the difference between an executor trustee. But you might need both of those people. You need both of those fiduciaries. Then you have to say, all right, what if I'm gone, but I still live? Who's going to take care of me? Who do I trust enough to make medical and financial decisions for me if I can't do it anymore? Now, quick note, we did mention this earlier. The role of the power of attorney, the agent, stops at the moment of death. So Paul Burrell is living. He's a 60-year-old guy, and he's running marathons. And I get hit by a bus, and I'm in a coma. I'm still around, so my power of attorney is going to take care of me. And then if I die 2 days later, the power of attorney stops. His job's over, and the executor picks up. It might be the same person. They just have to change uniforms. So we need to be thinking about, most importantly, who gets what and who's going to help me when I'm gone. Then you have to determine, what if I need a trustee? What if I need somebody to act as trustee either while I'm alive or after I'm gone?
And for those of you that already have estate documents created, this is a great time to pull them out and take a look at them. It's best practices to review them at least every 5 years. In our office, we review them with clients at least that often, and I know Paul and Sam do as well with their clients. But pull them out, take a look at them. Were they written when your children were in preschool, but now they're independent and launched adults? May need some updates. Do they still reflect what you want? Do they need updates for changes in the law? So if you haven't looked at them in a while and you've got them, this is a good time to pull them out and take a look at them and reach out to your financial advisor and talk about it and see if they need any updates.
Yeah, thank you guys. So if there's one takeaway from today's conversation, it's this. It's do not wait for a life event to force the conversation. Get ahead of it. Review your plan. Make sure your documents still reflect your wishes and revisit those with your appellate advisor. That's really important. And I think a lot of this stuff may be or may seem confusing to all of you. And that's what we are here for. That's what your appellate advisor is here for. We can, spend the time with you, review your documents, prepare you for your meetings with your attorneys, and help in any way to make this, difficult, situation or experience just be a lot easier. So before we open up for questions, I just want to thank everybody again for joining us. I want to thank Sean and Paul for their time and their expertise. One quick reminder, the webinar was recorded. You'll receive an email when the replay is available. And we also hope you can join us for our next webinar, Life Transitions, Navigating Life with Clarity, Discipline, and Thoughtful Planning. So with that, we've got a lot of questions.
Good questions on there too.
A lot of good questions. We're going to try to get through all of these as best as we can.
Before we move, Sammy, the survey results are in. 171 responses. Do you have an estate plan? 60% said yes. 34% said no. So roughly 2/3, 1/3. And 6% said, I'm not sure. So we've given you the call to action to go out and get that done. Let's get to the questions.
Great. So I'm going to start here, and I'll let you two decide who wants to kick it off.
Let's just start at the top.
Okay, we're going to start at the top. So if the trust is a valuable amount, do you stay in place to help the beneficiaries plan forward, and how far do you go into post-planning to help the heirs?
I'll take that one. That's kind of an easy one. So when you stay in place, I am assuming you meant how long do you remain trustee? In the living trust world, which I think is what we're talking about, you would remain as long as you need to be there, right? And that's usually until the moment of incapacity or you're gone, and you're not with us anymore. And, you can only control so much from the grave, and you can only control so much before you get to the grave.
Great. So the next one's not really a question. It's more of a testimonial, and I'm going to read this one. So I want to mention that I paid a little bit extra when creating my plan so that we could have a final review with both the estate attorney and appellate advisor so I could make sure my financial wishes were properly covered. My advisor brought up a few points in the review that would have cost me much more if I needed to change the plan after it was created. So it was well worth the added cost for the plan and needs for my peace of mind. So I think that brings up a great point. In our office, we try to do a lot, be part of this process and act as the quarterback or the intermediary, and prepare you for the meeting with your attorney, review the drafts, and kind of be a translator to make sure that your wishes are properly drafted and written in the document. So I think that brings up a good point. Any other thoughts?
Yeah, I agree. We do a lot of the same here. So in our office here, we'll have a meeting with the client before they meet with the state attorney to kind of flesh out what are the goals, what are the financial objectives, and that exercise helps think about a lot of the questions that we kind of talked about. As Paul talked about, how to ask the right questions. But what we'll also do is, relay what the goals and objectives are to the attorney, so that when you're meeting with the attorney, it's a really focused discussion. And we're also happy to review drafts as well and kind of guide through that whole process to kind of make sure that it's efficient and you get what you want and your wishes are carried out.
So the next one, if there is money owed to creditors, will they be able to access the funds from the trust? So how does a trust protect from creditors? Where do your debts get paid from is how I'd sum that up. Oh, you're muted, Paul.
Sorry. The standard revocable living trust would not prevent creditors from attaching that money. you could create an irrevocable trust, which has to be specially designed to protect it from creditors otherwise. So if you can access it yourself, so can your creditors. That's probably the best litmus test.
Yes, that's a great way to put it.
Can you talk about a Q-tip?
You want that one, or John?
So a Q-tip would be a specialized type of irrevocable trust. Couple circumstances when you use it. You might use a Q-tip when you're thinking about, I want to make sure money is available for my surviving spouse, but then I also want to guarantee it passes to my children or something like that. It can also be used as part of estate tax planning. Paul, do you have anything to add?
Yeah, you don't see it much. It's called what? Qualified terminal interest property. And it sort of restricts some of the assets. Most times you see it allows you to get it out of your estate, but lets your spouse have access to it. Is typically, I think, when you would see it. But with the new estate tax laws, nobody really ever talks about it.
Yeah.
All right, RMDs. What happens with RMDs when the beneficiary of a retirement account is a trust?
Great. That is a really good question. Sean, or you want me to run with that one?
You want to run with that one?
Yeah. So when you name a trust as the beneficiary of your IRA, and you can do it, you might do it for, protect the money from, in-laws, divorce, drugs, gambling. When you name a trust as the beneficiary, so first of all, the trust has to be an IRA approved trust. There has to be certain language that allows the trust to accept the IRA distributions. And there are two types of IRA distributions. There are traditional IRA distributions, which have not yet been taxed, subject to required minimum distributions. And there are Roth IRA trust distributions. Here's the sticky part. I'm going to have to get technical. The Roth IRA beneficiary rules are this. You don't have to take money out. I shouldn't say, in almost every case, a properly named beneficiary doesn't have to take money out of a Roth IRA for 10 years. So December 31st, following the 10th year after death, the money has to be either can grow tax-free for that entire time. If $5 million grows to $5 billion, the $5 billion is tax-free. So we don't have to worry about that part so much from a tax standpoint. The IRA distributions are subject to the IRA distribution rules, which mean there's a required distribution every year for 10 years, but the money has to be completely out of it by the end of the 10th year. So why is that so important? Doesn't sound so bad. Here's the problem. Trust income tax rates hit the highest tax bracket, 37% right now, at, I don't know, $15,000 or $25,000, not that much. So if the money stays in the trust, so we have an 18-year-old kid, we put $1 million IRA into the trust, that trust might have to take out $20,000, $30,000 a year, but the whole million has to be out in 10 years. And if we want to protect it from the child, it stays in the trust at the highest tax rate. IRAs are terrible wealth transfer tools. They were never designed for that. Roth IRAs are much better wealth transfer tools. And that's just an example of what you've got to do. So if it's really, really important that you start to think about how much do you love your kids or your beneficiaries when you start putting IRAs and Roth IRAs into trusts. Very complicated subject.
Yeah, so this is a great thing to talk about with your financial advisor and your attorney if this is something you're thinking about. The kind of a broad theme to keep in mind in this area is the more control you maintain over the funds and the more restrictions you put on it, the less and less tax efficient the inheritance becomes. So you may maintain more control, but the amount of money that's actually available for the beneficiary may be smaller because you lost more to taxes in the process. Mm-hmm. So it's a great thing to talk about with your financial advisor and your estate.
So interesting. I have a client that was a corporate executive and has a lot of money in IRA and put his IRA beneficiary into a trust, or named as a trust as beneficiary of his IRA. I said to him, what's more important to you, the taxes or not having the kids blow the money? And you know what he said? I don't want the kids to blow the money. I'll pay the taxes. Yeah. So So long as you know you can make an advised decision, again, we need the right questions to ask of ourselves and our professionals to do this right.
All right, next one. I thought real estate avoided probate in North Carolina. Is that not true?
So it could be that in North Carolina, so this is going to depend on your state, but it could be that in North Carolina is similar to Virginia, where you can put a transfer on death on the deed. It could also be something that's jointly titled, in which case, if one person passes, it passes to the other person on the deed.
So it depends, right? Because
Yeah, it depends.
depends how, it might, would you say, Sean, ordinarily not?
Yeah, ordinarily not. Yeah. So like if you're the only person on the deed and there's no transfer on death beneficiary, ordinarily it's going to go through probate unless you have it.
My house, when my wife and I die, is going to go through probate.
Yeah.
I don't know about yours. You might have a trust, Sean, in your state.
Yeah.
All right. I'm going to go through a couple of these here. These are going to be a couple quicker ones. Difference between his executor and trustee. We touched on that a little bit. Do one of you want to take that one quick?
Yeah, so the trustee means that that's the person who's going to be managing the trust. So if there's a trust set up, the trustee is the person managing the trust. The executor, as Paul talked about, is the person who, after you died, has got to marshal up everything, sell your house, distribute your personal property. That's the person who steps in after you die. That person needs to be kind of business-like, kind of organized, because it's a lot of organization required.
All right. Let's see here. We live in Virginia and our kids live in Maryland. We have an irrevocable trust. Is there anything special we need to do? Maybe more context is needed in a conversation with the advisor.
Having no facts, I would say no.
It sounds like you've got it buttoned up. It doesn't say, I mean, I would talk with your advisor, see maybe your state attorney, but it sounds like you've got everything buttoned up.
All right. Moving along here. Is there a list of what states have difficult probates? How do I find out if specific, state-specific probate? And another question is, does Pennsylvania have difficult probate? And Paul touched on this a little bit. Pennsylvania is a good probate state, or however you want to categorize it, where what that means is we typically don't see clients in Pennsylvania who reside in Pennsylvania needing trust because probate is not as difficult as other states.
Well, in another way of saying it is, I don't have a trust. My mother does not have a trust. Sammy does not have a trust. And very few of our clients don't have trust because we don't think they're necessary.
Yeah, you might be able to find, if you did a little internet searching, find a list somewhere, but I would say I would talk with somebody who has knowledge about your particular state, because the knowledge about your particular state, I would put more emphasis on that than something you found online.
Ask a lawyer, I think, is the best thing.
This is an interesting one. So just more clarification. If beneficiaries named on an IRA, my will leaves my house and personal possessions to designated beneficiaries. Can you create a revocable trust for the house only?
Yeah, oh, absolutely. Yeah, so the nice thing about estate planning is it can be customized to what you want. So for example, if you list your children as beneficiaries on an IRA, they're going to receive it. They'll open up an inherited IRA in their own names. But if you wanted like your home equity to pass in trust, you could certainly leave that to them in trust. Absolutely.
Is trust and will online a good place to produce these documents, or should I go through an estate planning lawyer? I know Paul's answer to this because this comes up a lot. I'll start with Sean, and I think it's going to be around the same consensus here, but I'll start with you, Sean.
So here's the difficulty with getting things online is so the cost, it's low cost, right? But the difficulty is their templates. They're not going to be customized to your values, to your situation. And I can tell you, anytime you start getting too far into kind of doing things yourself, when you really need to bring in somebody that got the expert knowledge, your potential for problems goes up. So the potential for, I thought I was doing one thing, but I really did another. The potential for that really goes up. So those are my thought.
Yeah, I mean, we see what we've seen happen quite a bit is these documents be produced online and then they're not accurate or not right, and they have to go through a Pennsylvania or that specific state attorney anyway to get them redone, and it ends up costing them more. It's like buying the cheap shirt. You end up having to buy the nice shirt and the cheap shirt. You should have just bought the nice shirt. So we don't recommend it. You can do it, just not recommended.
Yeah, I'm okay if you buy the store-bought green beans. I don't want you to buy the store-bought estate planning documents.
Yeah. This is an interesting point. And have you considered holding seminars for heirs so they can have a better understanding? I think that's a good point that we can bring back to the greater Appella. But I also think it's important to think about it in your own situation. And as Paul and Sean talked about, family meetings, communication, it's different for every family. It's different for every situation. But we have found the earlier you can bring in your family to this, to estate planning in your situation, the better the results are. And the more planning that can be done and the more levers that you can do.
I got a question for everybody. You can all raise your hand at the bottom of your screen. If you think it would be helpful for us to do a seminar like this for family meetings, raise your hand.
Oh, the number's jumping up pretty quick.
Yeah.
Yeah.
I think that's a great idea. I think that's a really good point. The best ideas come from you all, and we welcome them. So we appreciate that. Couple
Okay.
left here. Sorry, any other
Well,
points?
the youngest, Sean, the youngest guy on the call keeps that to give to the estate planning committee, right?
That's right.
Yeah.
Um,
Related to the topic about doing a discussion, having a seminar for heirs, one thing we haven't really talked about is if someone asks you to be an executor, what questions should you ask?
I think that's
I'll go ahead and share. So, if someone asks you to be executor, the first question you want to ask is, well, one, do you have estate documents? Do you have beneficiaries on your accounts? Have you, gotten everything done? Because what you want to avoid is saying, yeah, I'll do it. And then ending up finding out, oh, they didn't have their documents done. And now I've got a big mess.
That was a really great question, by the way, for that.
Yeah, that
I didn't
was
see who
great.
asked it.
All right. I have property ownership under the trust in my name in Iowa, and I've had problems cashing a check or interest payments. Do I need to have a checking account for the trust, or should I consider a holding company or something like that?
Yeah, you need to have a checking account in the name of the trust. I mean, when you have a trust, it is a separate legal body, just like a corporation. So you would need to name, if you don't have a checking account, it would be no different than you trying to deposit a check of mine into your account. Two separate legal bodies. So yes, you would.
Yeah, so I'll give you an example. We talked about irrevocable trust. Irrevocable trust is going to have its own tax ID number. I'm the trustee of a special needs trust for my brother. So the special needs trust has its own tax ID. We file a tax return every year, and I have a separate bank account that's titled in the trust. So yeah, you do need a separate bank account.
Perfect example.
Is it bad to have two children identified as joint POA? And I'll add another wrinkle to it is, should my child be an executor? When does it make sense to have children come into play in these documents or into your estate plan?
So when to have the children come into play? So that partly depends on how old they are and how you feel about it. So for example, if your children are maybe 18, 19, 20 years old, you may not be ready to name them as power of attorney or something like that. So you may have a family member or friend be the primary agent, and you may list the children as successor. When they get a little older, you might feel a little more comfortable about having them, amending the document and having them serve as the primary backup. Paul, you have any thoughts?
No, it depends. Again, like many of our answers are, it depends. But you'll know when they're ready, I think, is what I find is that, the people come in every couple months and there's that meeting where it's time, they've done whatever they've done, and you kind of christen them as the executor. My kids aren't there yet, by the way.
How about the joint POA?
I don't mind it. Some attorneys like it. If you're gonna have a joint POA, I would want them to act independently, meaning you don't need two signatures. So if one lives in Oregon and one lives in Maine, you're not FedExing documents back and forth across the country,
Yeah, the only thing
assuming
you
they
have,
get along.
yeah, you have to be careful. You have to make sure that it's not, if you have two people and they disagree, what happens? And so that's the downside. You need to think through, okay, what happens if they don't agree?
Which is a question, one of the questions you have to ask yourselves.
Another question, I've opted the corporate trustee route as I have no immediate family and do not wish for my cousin and kids to go through any of what I went through when my brother passed unexpectedly without a will. My plan is 2 years old and I want to review it as I feel like my mind is in a better place than when I created it. Is there anything in particular I should look for when critically reviewing an existing plan?
You mentioned the corporate trustee. Let me add a couple of thoughts on that.
Maybe what is a corporate trustee for those?
Yeah. So a corporate trustee would be, somebody that's an organization or a professional serving as trustee when you don't have a family member do it. There's a couple of varieties. Banks usually have a corporate trust department that'll serve as trustee. Our experience with banks, though, as the corporate trustee has not been particularly good. We have the clients that have used that have not had a particularly good experience. There are professional trustees, and we refer to a few of them. And the way that they're set up is they will serve as trustee. Firms like ours, Appella, can still, provide advice and manage the money and do financial planning, but they're serving as trustee. And that arrangement seems to work very well because it's a corporate trustee. You're getting, professional experience. You don't have to worry about personalities among the family, conflicts and things like that. So that would be something I might talk with your advisor about, maybe, who would they refer to or something like that. Paul, you have anything?
Nope. I think that's pretty accurate. Well, I think the one thing about a person trustee, if I name Sean as trustee, Sean might not be around to be trustee.
Yeah.
So corporate trustees live forever. That's about it.
So going back to my example where I'm trustee for my brother's special needs trust. The way we drafted it is we're going to name a professional trustee when I'm no longer able to do it. But right now it's me and then my cousin, and then when neither of us can do it, it'll be a professional trustee.
All right, we've got time for only a few more here, so we're going to try to wrap this up. One of the questions is any guidance on how to choose an estate planning attorney? Any specific credentials? If you were the audience, where to start?
I'll start, Paul, and then why don't you add on. So the first thing I would, I think talking with your financial advisor is a good resource. I know most of us have, relationships with attorneys that we know and trust. But in terms of what I would look for is make sure that most of their primary practice is doing estates and trust and their clients are similar to your situation. What I would try to avoid is where they're doing estates and trust and 10 other things.
I would agree with that. I think the other thing is for a lot of our clients, with $5 million or less, you don't need $1,500 an hour attorneys to draft these documents. Yeah. If you've got hundreds of millions of dollars, you do. I think, the most important thing that I find with attorneys, keep it simple. They keep it simple that in terms you can understand. I know that's hard for you to find. That's the difficult thing. Ask your Appella advisor because they probably have people that fit the bills for people like you.
Last question. Unfortunately, there's just a lot of questions in here that we're not going to be able to get to. Please feel free to reach out to any of us and we can certainly get these answered. If conflict between heirs is expected, do you recommend an independent attorney as executor or trustee? How do you ensure fees are reasonable?
I think yes. I think it's a good idea to have an independent third party of some sort, whether corporate or an attorney or somebody else, at least as a tiebreaker. Fees are fees. It's hard to shop fees because that's what the fees are today. You don't know what the fees are going to be when you die. So I think you rely on your expert team to provide you guidance in that area. That's part of the value that I think we bring is we filter out the people that make the most sense for you. And at least I can only speak for our office, but we have our own expert team of professionals in all different areas to help you, that we know where to send you depending on your fact set.
Yeah, I would agree. I think in this case, the most important thing would be the right attorney with the right experience. And I would prioritize, the right attorney and the right experience and the right fit over the fees.
Yeah. I think that makes sense. And a lot of these questions that we didn't get to, unfortunately, are a little bit more client specific or situation specific. And I urge you to reach out to your Appella advisor, go to AppellaWealth.com and look for an advisor in your area. Reach out to Sean, Paul, or myself. Just to wrap this up, I want to thank everybody taking time out of your busy week to listen to us talk about estate planning. It's a really important topic. We really hope you can join us for our next webinar. Again, Life Transitions, Navigating Life with Clarity, Discipline, and Thoughtful Planning. So with that, again, thank you all and have a great rest of the week and a great Memorial Day.
Thank you all.